Okay. Good afternoon, and welcome to today's University of Iowa Center for Human Rights webinar on race and international human rights. Today's webinar is part of our ongoing series on racial equity and human rights. It is co-sponsored by the American Society of International Law and Blacks of the American Society of International Law. Today's webinar has been approved for 1 hour of Iowa continuing legal education credit, and the activity number is 352338. I'm Brian Farrell. I'm Associate Director of the Center for Human Rights and a lecturer in the University of Iowa College of Law. I'm delighted to moderate today's conversation with a distinguished panel of international law experts. The University of Iowa Center for Human Rights recently celebrated its 20th anniversary, and throughout those 2 decades, we've stood for a commitment to human rights in the United States or abroad through our teaching, scholarship, and outreach. While we are a part of the University of Iowa College of Law, our center offers an undergraduate certificate program and engages with the entire UI campus and the broader community as well. Today's event is the 7th in our series on racial equity and human rights. Next Wednesday, August 5th at noon, we host the next webinar in this series, titled Moving Forward on Native American Rights. Past topics in this series have included activism, dialogue, and healing, the right to protest, understanding white privilege, historical perspectives on anti-Black violence, police, prosecutors, and race, health, and COVID-19. Recordings of these previous webinars and resources can be found at our website, www.uichr.org. A recording of today's webinar will be posted to the website later this week. Also on our website, you will find a link to donate to the center. We welcome your support for our efforts through your tax-deductible contribution. The format for today's webinar will consist of contributions from each of our panelists for approximately 10 minutes each, followed by question and answer from our audience, which I will moderate. You can submit questions throughout the program today via the Q&A button in Zoom. As I mentioned, we have a fantastic panel for today's webinar, and I will briefly introduce our panelists now. Our first panelist is my colleague, Adrienne Wing, our center's director. Adrienne is also Associate Dean for International and Comparative Law and the Bessie Dutton Murray Professor of Law at the University of Iowa College of Law. Adrian will be followed by Anna Spain Bradley, Professor of Law at the University of Colorado, and the incoming Chancellor of Equity, Diversity, and Inclusion at UCLA. Our final panelist today will be James Gadee, Professor and Wing Tat Lee Chair in International Law at Loyola University Chicago School of Law. Thanks again for joining us, and with that, I will hand things over to Adrian.
Hello, everyone. Can you see me? Are we okay? Am I sharing? Okay.
Adrian, I don't see your video.
Okay. All right. Let me, video. Yeah. Okay. Okay. Everybody can see me now, right?
Yes.
All right. Good afternoon, everyone. Now let me try and share my screen that I was trying to do a minute ago. All right. Now, can you see that screen? Yes? Yes,
Yes, we can.
Yes. Well. All right. Thank you, everyone. Good afternoon. Thanks, Brian. As Brian said, I am the director of UICHR, and I'm very pleased to be part of this webinar. Brian told you about our racial equity series, but we've had a total of 12 webinars this spring and summer. We have reached over 3,000 people. I'm very delighted that BASIL, Blacks of the American Society of International Law, and ASIL are co-sponsors of today's events. And I am very grateful for the participation of my colleagues, Professor Anna Spain Bradley and James Gadee, who are among the most famous Blacks in international law in the United States. In these times, focusing on race issues in the age of COVID, most attention has focused on Blacks and US law and US issues. The purpose of our webinar is to take us beyond the domestic law level and to look at international law issues and foreign policy. My presentation is going to give some historic perspectives on the involvement of Blacks in international human rights issues. And these are, on this slide, are the subjects that I'm going to very briefly discuss. In 1946, there was a group called the National Negro Congress. It petitioned the brand new United Nations concerning the status of Negroes. Then African Americans were called Negroes. So this group, the NNC, delivered a statement on racial discrimination to the UN Secretary General. The group did not stay in existence very long after that, but made an important effort to see Black issues in the Jim Crow era of legal segregation as extending beyond the bounds of the United States. So this was incredibly radical. In 1947, the NAACP, which still exists today, and I hope all of our listeners are familiar with, it submitted a 96-page petition called An Appeal to the World to the United Nations. It demanded accountability for human rights violations against African Americans in the United States. That petition, which was edited by famous scholar and NAACP founder W.E.B. Du Bois, covered topics ranging from slavery and Jim Crow to voting rights, criminal justice, education, employment, and access to healthcare. Sound familiar? Mrs. Eleanor Roosevelt, who was the former First Lady, was then a member of the US delegation to the United Nations. And she was opposed to the petition since it would be very embarrassing to the United States. In that Cold War era, the Soviet Union proposed that the NAACP's charges be investigated. The United Nations Commission on Human Rights rejected that proposal, and the UN took no action on the petition. In 1951, the very short-lived Civil Rights Congress presented a 237-page petition to the United Nations called "We Charge Genocide." This petition stated that the U.S. violated Article 2 of the new UN Genocide Convention. The petition quotes the UN definition of genocide: any intent to destroy in whole or in part a national, racial, or religious group. It concluded that the oppressed citizens, Negro citizens of the United States, segregated, discriminated against, and long the target of violence, suffer from genocide as the result of the consistent, conscious, unified policies of every branch of the government. Under great pressure from the US government, the United Nations did not even acknowledge receiving this petition, even though it was delivered in New York by Paul Robeson, who was a famous entertainer and political activist, an African American. In 1967, Dr. Martin Luther King Jr. made a famous speech going beyond his usual focus on US civil rights issues. He noted his opposition to the Vietnam War and indicated the war violated the spirit of the UN Charter, the right to self-determination of the Vietnamese people, as well as it undermined the Lyndon Johnson administration's Great Society program that was trying to deal with anti-poverty purposes. Quoting Dr. Martin Luther King Jr., "As they spread the propaganda of war, we must spread the propaganda of peace. We must combine the fervor of the civil rights movement with the peace movement. There is an element of urgency in our redirecting American power. We are now faced with the fact that tomorrow is today. We are confronted with the fierce urgency of now." Dr. King was subjected to unbelievable criticism for daring to criticize US foreign policy, even from those who normally supported his civil rights movement. Jumping now to the 1980s, the Congressional Black Caucus and the group known as Trans-Africa, as well as other groups, were involved in organizing the Free South Africa movement. Their activities led to the passage of the Comprehensive Anti-Apartheid Act of 1986 in the Congress. President Ronald Reagan vetoed that act, but they organized and were able to override his veto. This act was an important American contribution to the eventual end of official race discrimination in South Africa. In 1996-97, the National Black United Front petitioned the United Nations alleging genocide regarding the disproportionate effects of crack cocaine and HIV/AIDS in the Black communities. Acts of genocide were also attributed to the government's use of taxpayer money to wage war on Blacks in a variety of areas. In 2014, during the UN Convention Against Torture Committee review of the United States, a group of 8 young activists from Chicago submitted a shadow report using the name "We Charge Genocide." Their report, the 2014 report, addressed police brutality toward Blacks in Chicago, the lack of police accountability, and the misuse of tasers by the Chicago Police Department. My colleague, Professor James Gathie, who will be the third speaker today, will bring us up to date with respect to the current activities involving Blacks in the UN. I'm going to conclude my presentation with mentioning several Black lawyers who have played an important historical role with respect to international human rights. These are our heroes and our sheroes. They are not generally well known to the public or even to many African Americans. So this slide shows you some living heroes and sheroes. On the top left, Attorney Gay McDougall was a vice chairperson of the Committee on the Elimination of Race Discrimination, the CERD Committee. She's currently a distinguished scholar in residence at the Leitner Center on International Law and Justice of Fordham Law School. On the bottom of the slide is retired Ambassador Robert Van Lierop, who represented the island of Vanuatu at the United Nations for 14 years. He was also vice president of the United Nations General Assembly during its 43rd session. The final person featured on this page, top right, is retired Judge Gabrielle Kirk Mcdonald. She is the former president of the ICTY, which is the International Criminal Tribunal for the former Yugoslavia. She was also the American arbitrator on the Iran-United States Claim Tribunal, and she's a former U.S. District Judge of the United States District for the Southern District of Texas. In other words, a U.S. federal judge. In addition to these living senior heroes and sheroes, I want to conclude with a few people who have passed away and are likely to be even less well known. On the top left, Dean Haywood Burns. He is the late dean of the City University of New York Law School. He was a legal advisor to the drafting of South Africa's interim constitution, as well as a founder of the National Conference of Black Lawyers. Next to him on the top right is the late Professor Y.N. Cly of the University of Regina in Canada, who was the author of a book called International Law and the Black Minority in the United States. He was also the chair and founder of the International Human Rights Association of American Minorities. On the bottom, at the left, you will see the late Harvard professor Clyde Ferguson, who was an ambassador to Uganda and was the only Black who has been president of the American Society of International Law. He was the first Black professor at Harvard Law School. Next to him, in the middle bottom, was the late Howard University law professor Goler Butcher, who was a consultant to the House Foreign Affairs Subcommittee on Africa. The American Society of International Law has created the Butcher Prize in Human Rights in her honor. And finally, on the bottom right, is the late Ambassador Patricia Roberts Harris. She was the Dean of Howard Law School, and she was also the first African-American woman to serve as a US ambassador, and that was to Luxembourg. So thank you all for your attention. I hope my presentation has been enlightening. Now I will turn it over to my colleague, Professor Anna Spain Bradley, and I want to congratulate her on her recent move where she's going from Colorado Law School to UCLA. So thank you all very much for your time, and I look forward to the questions.
Hello, everyone. Thank you, Professor Wing. Thank you to the University of Iowa's Human Rights Center. And thanks to everyone who's tuned in today to be a part of this essential conversation about race, racism, and international human rights. I think that one of the things that attracts us all to the word human rights is its promise, that it stands for an aspirational ideal that every person matters. Every person is worthy of freedom, of equality under the law, of dignity and other core principles that we now understand as human rights. But human rights has work to do when it comes to the problem and the challenge of eradicating, eliminating, and addressing racism. And I wrote about this in an article you can find online. It's called Human Rights Racism in the Harvard Human Rights Journal last fall. A year ago, I said, racism in all its forms is the under-acknowledged human rights problem of our day. Today, there is acknowledgement, global acknowledgement. People are protesting in the streets. There is reform in private sector and corporations. There's renewed conversations about what the world and our society can do about racism. In the midst of all of this, we still lack a global consensus and global answer to a very straightforward question. What is racism? So that's what I want to engage all of you in thinking about in the next few minutes or so. If you have ever experienced racism, you might describe it like this: not being promoted at work, being denied a rental application or a mortgage, having means of voter suppression make it very difficult or impossible for you to vote. We understand in the United States that these kinds of activities are discrimination on the basis of race. Maybe you've been called a racial slur. Police have attacked you. Hate crimes have been committed against you on the basis of your race. All of these things are manifestations of a deeper problem that we use the word racism to try to grasp. And all of these things are connected to a very important yet problematic concept of race. Race means different things around the world. In the United States, we define race on the US Census form. The government sets out the boxes you can check to define who you are as a matter of your race. Yet, in 1915, going back to Professor Wing's important history, a group at the UN called UNESCO wrote a seminal report called The Race Question. You can find it online. I encourage you to Google it and check it out. In that report, the international community determined back in 1915 that race has no basis in biology or science. Instead, its roots come, and I quote from the report, from the minds of men. Race is made up, and yet it is something that we have experienced in our life as being real. So it has real social, cultural, and economic and political impact. The result is that race has been legalized by many governments to categorize and separate people. And those separations are often put on a hierarchy that renders some people more important and more protected, and others, many others, vulnerable. As a result, millions of people around the world are denied their inherent human rights of life, equality, liberty, and most importantly, dignity. So there has been a push in the human rights world for a long time by certain groups to get racism on the agenda. And Professor Wing mentioned this back in the negotiations that led to the United Nations Charter. W.E.B. Du Bois and other leaders in the US had a call to include prohibitions against racism in the charter. Their call was denied. A few years later, they called to have racism in the UN Declaration of Human Rights. Du Bois wrote the problem as he saw it was, quote, a complaint mainly against a discrimination based mainly on color of skin. He called racism indefensible and barbaric. Finally, in 1965, the world gets together and gives us a treaty. It's called ICERD for short, but it's the Convention for the Elimination of Racial Discrimination. And in the history of all the many people who served as delegates to their country, we see the problem that we face now. A delegate from Jordan proposed that racism or racial discrimination was fascism, colonial, tribal, Zionist. A Western European nation stressed that racism comes from Nazism and anti-Semitism. African nations and the then USSR, Soviet Union, called out colonialism and apartheid. The representative from Saudi Arabia questioned whether anti-Semitism wasn't better understood as religious intolerance. And the representative from Israel responded that Jewish people knew exactly what anti-Semitism was, for it had too long been its victim, whether for racial or religious reasons. To those who have suffered, qualifiers were not important. Ultimately, nations could not agree. So today, in international law, the only treaty that defines something close to racism defines it as racial discrimination. It defines it as a distinction, an exclusion, a restriction or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms. It only names two particular kinds: apartheid and segregation. And this is fundamentally a result of the fact that countries could not agree on the other forms. So the short answer is that international law today in a treaty provides us a definition for racial discrimination, but does not define racism itself. Here's where I argue that racism as a word captures more of the harms than racial discrimination. It's vital to understand that racism is more than discrimination. It's also rooted in an aggressive ideology that motivates behavior and, unchecked, poses a core threat to the principles and purposes of international law, namely peace, security, and human rights. Racism dehumanizes people and communities, not only by denying their inherent equality and dignity, but doing so on the basis of a constructed category of race that was designed for the very purpose of separating people into a hierarchy meant to elevate some and suppress many. In his best-selling and famous book, Derek Bell, Faces at the Bottom of the Well, he describes the unique pain that racism inflicts. He says, Black people are the magical faces at the bottom of society's well. Even the poorest whites, those who must live in their lives only a few levels above, gain their self-esteem by gazing down on us. I say this to all of us who've experienced racism. There is a pain there. I remember being 5 years old and playing the next door neighbor's sandbox, and a friend was over, and he was a little boy, maybe a few years older than me. He was white, and he looked at me and he called me the N-word. And he said, "You can't play me here. You need to get out." I remember running home crying because I didn't know what the N-word meant. I was 5. My parents had yet to have the talk with me. And yet I felt the harm that that slur carried. The sense that I was somehow inferior to this other boy, mainly on something that I couldn't control, something that he believed I was born into, something that had been named for me and put on me, my race. Let me close by saying this. Racism today is a tool of oppression. It has global reach. Solutions to the problem need to also have a global reach. And this is why I believe that international law, and within it, human rights law, is a tool that needs to become better equipped to rise to the call to address and deal with racism. States need to do more. One treaty is not enough. People need to do more. We need to ask ourselves, is education alone sufficient? Does education about the problem result in increased understanding, increased empathy, and behavior change? What other tools do we have at our disposal? I write about these and offer some suggestions in that article that I mentioned, but I know many of you have experienced the pain. And the whole promise of human rights is that people going forward don't have to experience such pain. We don't have to be dehumanized. We deserve and demand the right to be treated with dignity, no matter who we are, no matter what our identity, and that is what we need to make human rights a tool for once again. So I'll conclude there, and I really look forward to further engagement in the questions period. But let me turn the floor over now to my distinguished colleague, Professor James Gatti, who is the Wing Tatley Chair of International Law at Loyola University Chicago School of Law, a beloved professor and mentor to many, and a leading scholar in international law. James.
Thank you so much, Professor Bradley. That's a very kind introduction. I have enjoyed your remarks, and Professor Adrian Wings as well. So I want to first begin by thanking Professor Wing and Brian, as well as the Iowa Law School Center for Human Rights for inviting me to this discussion today. I also look forward to the conversation. I want to make three brief points. First, I want to argue that the United States has historically sought to exclude domestic scrutiny of its human rights record, including on questions of racism, by rules of international law. And the second claim is that I want to make is that in a recent rare win, the United Nations Human Rights Council voted to establish an independent commission of inquiry in the post-Floyd moment, and I'll talk about that. I think that example shows the power of activists and leaders on questions of race, circumventing the traditional hostility of the United States to its scrutiny, to the scrutiny of its record on race by rules of international law. And finally, I want to say something about the epistemic silencing of race in the field of international law, and the very important role that the type of discussion we're having today can have on opening up questions of race to scrutiny by rules of international law. I guess the backdrop to all this is that it's a major plank of US foreign policy, perhaps until this administration, to scrutinize the record of other countries on human rights. It's often a precondition for receipt of foreign assistance and all sorts of other goodies that the US offers to its friends around the world. And it's been a central plank of almost every administration. But let me first go back to my first point, the traditional hostility of the United States to scrutiny of its domestic record on human rights. And I'm talking about, of course, the modern human rights movement of the United Nations framework. I think one place to begin, there are many places one could begin, is what many people refer to as sort of the ghost of Senator Bricker in the 1950s, in the early 1950s, who led hearings in the Senate, in the United States Senate, because he wanted to amend the US Constitution to provide that if a treaty conflicts with the Constitution of the United States, that it would have no force or effect. This debate, I think, is remembered because this was really the height of the litigation around segregation, and many saw this debate as anticipating decisions like Brown v. Board of Education, ending segregation in the educational system. And Senator Bricker wanted to block the ability of any international human rights scrutiny to end de jure segregation by sort of using rules of international human rights, sort of closing that door completely, with support, of course, of many senators, especially from the states in the South, that were really supportive of this amendment. The other tool that is often used by the United States when it signs international treaties, I'll come to that in a minute, of course, are reservations, understandings, and declarations, which really limit the domestic applicability of rules of international human rights law that may be ratified by the United States. For example, the International Covenant on Civil and Political Rights, which is the only, I think, major international human rights treaty that the United States Senate has ratified. But really, the other tool that is available is the United States just sort of doesn't sign on to many of these treaties, including, of course, the one that Professor Anna Spain Bradley just spoke about on the International Convention on Elimination of All Forms of Racial Discrimination. The United States is not a party to the International Covenant on Economic, Social, and Cultural Rights. It's not a party, I think, only with Somalia, the last time I checked, on the United Nations Convention on the Rights of the Child, and CEDAW on women's rights. There's just a hostility to the domestic scrutiny of the United States by rules of international law. And I think that it's particularly troublesome because the United States often prides itself as at the place, where that exemplifies this commitments to rights. So that's just the first major point that I wanted to make about this domestic reluctance to have international legal scrutiny around questions of human rights, including in the judiciary, that sort of uses doctrines such as the non-self-executing doctrine to foreclose the applicability of international law in cases that may be filed. So the second point I wanted to go to is the recent decision in the United Nations Human Rights Council in June, in a resolution that was that came from African countries to establish a commission of inquiry to establish the facts and the circumstances related to systemic police violence. The target was of course, the United States. This resolution was opposed by the United States, by many countries in Europe. Traditionally, they've been very hostile to any discussions around race in the United Nations. One other very important critical fact here is that the discussion in the United Nations Human Rights Council arose in part because of the important work of Professor Tendai Achiume, who is the Special Rapporteur on Contemporary Forms of Racism, Racial Discrimination, Xenophobia, and Related Intolerance. And really, she has done a remarkable job even before this moment of uprising against racism. It shows really the importance, this example and the decision in June shows the importance of the work of individuals like Professor Tendai Achiume, working together with many groups and many countries to open up discussions around questions of race and racism, particularly in the United States, that have traditionally been shut down, like I mentioned a couple of minutes ago. So there is promise, notwithstanding the fact that the doors and the windows and all the crevices are shut down, and the United States tries to shut down all those paths to international legal scrutiny of its domestic human rights record, especially on questions of race. The last point I want to make really is around scholarship and on race and international law. Now, we have on this panel the very distinguished Professor Adrian Wing, who has really done some of the most important work on questions of race, and not just race, but linking that to gender and coming up with what she calls critical race feminism. Very important insights in her work, including issues relating to the spirit injury that has resulted from enslavement and many years of the effects of that to date. There are scholars like Professor Henry J. Richardson and many of the others that Professor Adrian Wing mentioned. But really the field of international law is a field in which questions of race are rarely the center of discussion. They are segregated as peripheral, as unimportant, as not relevant. And if I can give you a very specific example, there's been a huge revival in the study of the history of international law. And it's amazing to me that in this revival of the study of the history of international law, first, that race has not been very central, but questions such as reparations have not been a central question in the discipline of international law. And I think that the way I think about the importance of scholars engaging on this question is sort of thinking about the field of international, like many other fields. You know, there are these people who do work relating to race and identity, and then there are these other people in the discipline that do the doctrinal work, but they're like two ships passing in the night. They never ever get together, not in the same room, not in the same conferences, not in the same conversations. And I think these are some of the things that I think need to be challenged. I'm personally very committed in every engagement to challenge what I call the epistemic silencing on questions of race and identity, and the denigration of the scholarship and the individuals who bring up these issues, and the techniques that are used in the discipline, including the gatekeeping by journals and by whether it's student-edited journals or peer-reviewed journals, or how conferences are set up, that make it difficult to have conversations like this, that we had to wait for this moment of racial reckoning, for these issues to be recognized as important, as significant, as worthy of the attention, not just by scholars of color, but by white scholars and other scholars, so that these issues are regarded as systemic, important, integral, and significant as any other issue in the discipline. So anyway, maybe I have spoken beyond my 10 minutes. Those were my 3 points, and I look forward to the conversation. I turn it back over to Brian.
Thank you so much to all of our panelists for their wonderful contributions. We'll turn now to audience questions, and I invite all 3 panelists to unmute their audio and activate their video. My apologies if we can't get to all of the questions. I may combine some of the questions if they are of a similar nature. So I'd like to start with a question. James, you talked about hostility, American hostility to some of these invocations of international law. And I'm wondering if the panelists can perhaps comment on the potential for the invocation of international human rights law to not just be met with hostility, but actually be counterproductive, either by providing sort of an internationalist boogie person to lay blame to, or causing the United States to further disengage with international law institutions as it has, particularly over the last several years.
James, it's a good one for you.
Yeah, thanks, Brian, for that question, and whoever asked it. I think that there is a discourse about backlash against rules of international law generally, and of international courts in particular, and that many people have associated the current moment of white nationalism and white supremacy and whatever Trumpism is going on as responsible for the backlash. My point is that I think that the legitimacy of the efforts by generations of people who've been struggling for the rights of people who are formerly enslaved or colonized is really very important, and that it cannot be underestimated. And it may very well be that governments, including governments from where I come from, are very angry when those issues are raised because they challenge their power. But I think that the legitimacy of norms of international human rights does not arise from the fact that governments acknowledge and recognize. The legitimacy arises from the inherent dignity of these people, as both my panelists have noted. And so I think that the movements that have really been very effective in this country on questions of anti-racism, if you think about this, the anti-apartheid movement and the efforts of people like Gabe McDougall and others that Professor Adrian Wing mentioned, and the successes that they had in making these issues really very important in the public profile, cannot be underestimated. And governments will always, powerful individuals and institutions will always delegitimize and push back, but that does not invalidate or delegitimize. And in fact, I think it gives vigor and legitimacy to those causes. So that's what I would say.
And Brian, I'll just add this, that I think, again, everyone who has skepticism about the project of universal human rights does so with good reason. There are reasons to be skeptical of the project, because international law has always been created by and for nations. And so as somebody who used to work at the US Department of State, and I say this now in my personal capacity, I can tell you there were a number of negotiations that the United States was present and a party to, where human rights was either put on the agenda in order to ensure that another country came into compliance or came into line with US interests, or it was left off the agenda because it would complicate the United States getting a certain interests that it wanted. And this is precisely what both of my colleagues have mentioned, as did I, with the founding of the United Nations and the drafting of the UN Charter. It could have very well been a charter that named and called out racism as a violation of human rights and a lot of other human rights violations. It was not, for reasons that were designed to serve the interests of the powerful nations that carefully constructed what that charter was and what the post-World War II world order would look like. And the United States, with Franklin Delano Roosevelt, was at the front and center of that project. So I think we are right to be skeptical. But I would also say that for all of humanity, if we don't have an aspiration of what we can become, how we can actually move through the world treating each other with dignity, then what is the project of humanity? So we need to remain skeptical, but not let the skepticism get in the way of putting plans and progress towards the real aspiration of human rights.
I'll turn to another question. Given many of the elements of the international law system, such as power sharing in the Security Council, the global North-South divide, and emphasis on important or Western states driving the formation of customary international law, is the entire structure of international law broken when it comes to addressing race in the international context? If the system is designed to keep those viewpoints absent at the state level, and I think you just alluded to this, Anna, can it really address internal domestic race issues?
I guess I'll start off. Some would say the system is not broken. The system is working as it was designed to work. So just like domestic law, people are looking at police brutality and saying, is the system broken? Well, it depends who you look at. The system was designed by powerful forces that were colonial and neo-colonial in nature. And so we've been trying to glom onto it things to make it applicable to most of the planet. And that hasn't happened. And so part of that is political. It's not necessarily anything wrong with the law, whether law is domestic or international, but political decisions that governments make to not listen to international law. And since there's no international police force that can go in easily and arrest an entire government, that makes it very hard to try to make the norms, actually have any real teeth. I should say, though, there is the International Criminal Court, which has, upon occasion, indicted, different leaders, and sometimes those leaders actually get arrested and brought, to The Hague and put on trial, etc. But, other than some small exceptions, very, very difficult to make such a system work with over 200 nation states.
And I'll just
Anna or James, anything to add?
Just to chime in to say, I think there's a really common circumstance that I would love for everybody in the public to be aware of, and it's this. When you look at when nations get together and have conversations about racial discrimination, and whether this is through the treaty or other mechanisms, there's a common thing that happens, and this is what it is. A nation will say, yes, racial discrimination is abhorrent, we should eradicate it, but we don't have that problem in our country because we all identify as the same race, or we don't use race, we identify in other ways. And this is back to Derek Bell's brilliant idea that it doesn't matter where you are in the world, what human community you're a part of, there's always a structure, a hierarchy in which certain people are on top and certain people are on bottom. And I think both Adrian and James's work and many other scholars that James mentioned that don't get enough recognition in our field have called out the fact that those hierarchies have been racialized for a very long time with whatever conception is whiteness or maleness or being heterosexual at the top and other factors being at the bottom. And that's the system that we're trying to reform. Can law do it alone? No. Do we need political momentum and strength? Yes. Is there a room for the public? And here I'm talking about the global public to come together in solidarity to say, we need to fix this if we're going to have human civilization? Yes. So we need people to understand, as Adrian said, that it's not that the system is broken, it's that the system was designed a certain way at a certain time, and it's time to redesign the system.
Yeah, if I may, Brian, I think I agree with both Adrian and Anna. And I think one of the other things that we could say is that, which is what lots of the activists who've been highlighting questions of race in these international legal mechanisms have tried to do is that the international human rights system is a state-based system. It's sort of, it's controlled by the states in the United Nations system. That institutional framework, I think, is different from a lot of the grassroots groups that do very important work. So for example, the pressure that was applied here in the United States against the apartheid government so that it could make major concessions did not start with the United States government. It started with groups at the grassroots, often Black and brown people, not white people often, but in alliances that led to change, both here and even in some of the countries in Europe that started shifting against apartheid in South Africa. So even within recent historical memory, I think we've got to separate the institutional infrastructure from the movements, the very vibrant movements that raise these issues that are often marginalized and not recognized for the very important work that they do. And the way in which our disciplines tell the story about these rules by foregrounding that institutional structure, but by ignoring the important work that is done within the crevices of that system that move the change. So the last thing I'll say might sound a little academic and scholarly. Bhupinda Chimney has a great article recently in the American Journal of International Law, Third World Perspectives on Customary International Law, which is reimagining customary international law from the ground up, from the perspective of from individuals, from social movements, not from the perspective of states. You know, it's a really powerful retelling of the types of examples that we are giving, which is why I think the vitality of the international human rights system is based. The fact that we have Professor Chiume as the special rapporteur who was leading that discussion is a very good example of how a state-led system can be shifted in a way that opens up debates and discussions that have previously been closed down. So I think that's also something to take into account.
We have a question here about the American stance over the 75 odd years of the existence of the United Nations and the human rights system. How consistent has the American stance toward international law been? We talk about this hostility or this exceptionalism, and how much has that changed depending on partisan politics in the United States, depending on control of the presidency and the Senate?
Clearly, it ebbs and flows because depending what party is in power at what particular time, that party may be more oriented toward internationalism and globalism than into American exceptionalism. I think we are experiencing at this moment under the current administration, one of the examples of American isolationism and not wanting to embrace some of the principles of, some of the prior administrations. But no matter what the administration is doing internationally, it's always going to be affected by the domestic politics of the forces within that party, at that particular historical moment.
And I'll take that question to, think about people in the Midwest. And I say that as somebody who spent a good part of my childhood in Ohio, and thinking about how growing up, what was the story that we were taught about America's place in the world? What was the story that we were taught about the value of international cooperation, about the need for international trade, about the idea of having alliances between other countries to keep ourselves safe? And I think all of that's to say that there's been a big shift, and I don't know if it's generational, I don't know, the root causes, but I think a lot of people in the country today do view America as being separate, as it's possible to separate America from other places. And yet today in 2020, whether it's through technology, whether it's through global supply of food, of clothing, of things we want to buy. We are more interconnected than we probably have ever been. And so there's a disconnect between the reality and the story. And I think right now, the government that we have in place in this country is telling a very different story about America's place in the world. And it's not the story that we've had that America leads. And it's a story of a retreat from international institutions, retreat from international cooperation. The story is still being written. We don't know how it's going to end. But for everyone who's participating today, I would say, think about what you would like your role and America's role to be in the next 10 to 20 years. And how do we as people in the public make our voices heard about what that should look like? A world that America's a part of, that America helps hold up, and that America benefits from. So we are in this conversation right now. It is still being written.
So Brian, if I may, just one very quick addition to that is to say that one other place that we have seen some shutting down of the international legal mechanisms that might be helpful is in the courts with the shutdown of the Alien Tort Statute in the last couple of years. This has really been an important avenue for victims of human rights abroad to come to the United States to seek relief for human rights violations that occurred abroad. The fact that that door is being shut down by the Supreme Court is another example of the importance of the voices of people to be heard and to continue these struggles, because it's not a one event situation. I think some of these things are capable of shifting and changing. I think now is a dark moment, to be honest. I think there's a lot of repudiation of lots of norms of international law, some of which are helpful that the United States has stood for, but I don't think that it will always be that way. So the vitality of the forces working for rights, both abroad and here, I think must continue.
We have about 4 minutes left, so this may be our last question. Senator Bricker's opposition to human rights treaties was motivated by racial animus, but it was also deeply gendered. To what degree does the current study of race and international law address issues of intersectionality?
Yes, intersectionality is one of my major areas of specialty. Intersectionality means rather than just look at race or just look at gender, you have to look how they intersect. In other words, how women of color are treated, not just Blacks or not just women. And so historically, of course, all of these treaties were based on kind of one theme. Race, there's a race convention and there's a separate women's convention. However, recently there is some intersection. And so the committee that's for the race convention did a recommendation that actually said, when we look at race, we must look at intersectionality. We must look at the intersection of gender or other identities. So since a lot of the modern scholars or people working in international organizations are now familiar with the whole concept of intersectionality, which has been made famous in part by Professor Kimberly Crenshaw of UCLA and Columbia Law Schools. There is an effort, small as it may be, to, when we talk about international law subjects, to look at them in this more complex way at the various intersectionalities that might exist.
I'm going to ask you one last question. We'll see if any of you can give us a relatively brief answer here, but the formal impediments to US domestic incorporation of race issues within international human rights instruments preclude advancement. Yet the architecture of international human rights discourse and dissemination is oriented toward power structures and publication poll stars that also limit this advancement. So agreeing that grassroots politics and civil society influences create interesting and meaningful pathways for change, do you have any thoughts on resourceful alliances between international law and civil society?
I'll just briefly say, I think we can find some good examples in the world of post-conflict peace building. So when different parties, civil society, nations, government actors have to come together and negotiate a peace. And when that's done well, we can find some good examples, but it comes down to the question of power and how power and when power can be shared. And we know that nations are very reluctant to turn too much power over to civil society. We know that nations are also reluctant to turn too much power over to international law. But we're in a moment in the world where we can no longer afford for nations to hoard power. People demand to be participants, full participants in the shaping of their lives. So in short, I think the question comes down to power sharing.
So if I may, on the last question, I think Adrienne completely understated her very important work. You know, anyone that hasn't read Adrienne's work on critical race feminism, of which she is the founder, should, because I think it is really the foundational work. And I'm really disappointed with many of my white colleagues in the discipline who have really underestimated her very important work. I think it deserves more prominence. I know, Adrienne, you wouldn't say this, but I can say it. I'm very proud of that work and its significance, and all the mentoring that you have done to mentor people, and the work you've done with people like Vasuki Nasi and so many other feminists from the third world to really occupy that space. It's been occupied by white female scholars who have not yielded that space to the kinds of scholarship that that you have done. So on this last point, I think I want to invoke Kimberly Crenshaw's idea of reform and retrenchment. There's going to be reform, but there's always going to be pushback, and I think that's the reality. But one other place we can look for inspiration is the way that indigenous movements have really in alliance with each other across the continents, because they face hostility across continents. You know, the settler, countries of Australia, New Zealand, in many places in Africa, here in North America, Canada, indigenous Latin America, not to forget, and the very important role played by the Inter-American human rights system in the litigation there that has been cited in litigation in the African human rights system. This movement, I think, gives a lot of inspiration for what is possible when alliances are built and sustained across many forums, across many years, with really amazing people who've been special rapporteurs in the UN system on issues of indigenous rights that have made these issues very high profile issues, with all the important decisions that have come from the United Nations. Many people working across many divides over long periods of time, I think is a really good example that gives one hope about what is possible.
We will leave things there. Thank you so much. I'm so grateful to our panelists for such a wonderful conversation today. It's been a privilege to be a part of it. Thank you, Professor Gadi, Professor Spain Bradley, and Dean Wing. Again, we want to thank our co-sponsors, the American Society of International Law and Blacks of the American Society of International Law. And one more time, I wanted to mention that the event is approved for 1 hour of Iowa continuing legal education credit. The activity number 352338. A reminder that a recording of this presentation will be available later this week at our website, www.uichr.org. And again, we invite you to join us next Wednesday for our upcoming webinar, Moving Forward on Native American Rights. Thanks again to our panelists. Thanks again for all of you for joining us, and have a great afternoon.
Thank you.